Remember, I started off by asking whether Mr. Brown consented to the entry of a protective order. Remember, that's the first thing I asked you after
Right.
you identified yourself?
Yes.
He said no?
Yes.
And that's C, letter C on this form that I must complete. I can either check that box
Yes.
or the next one.
Mm-hmm.
The next one says if he does not consent, then we must have a hearing.
Okay.
And after the hearing, all the evidence, I must then find, quote, that there is clear and convincing evidence. So it's beyond the lower standard of preponderance of the evidence.
Mm-hmm.
So clear and convincing evidence that the respondent committed the acts of abuse.
Mm-hmm.
Okay. So that's the reason why I'm trying to...
And under family law code, isn't false imprisonment one of those items that is...
Okay, let's assume that you conclude that, but I must find there was clear and convincing
Right.
evidence.
Mm-hmm.
Okay. Anything else you want to tell me?
No, I have some pictures of my driveway, and I could show you how he had positioned his car.
Okay.
Your Honor, may I have a...
You may.
And I also have, my mother is a witness because she was in the car with us, and the children, if you would be willing to speak with them in chambers.
Regarding what?
What they saw, because they were with me when this occurred.
If Mrs. Sanchez is offering the evidence, Your Honor, I object because it did not depict Mr. Brown's car. That depicts somebody else's car. When he drives up, I don't think it's competent evidence.
Okay, I don't believe she's offering to show Mr. Brown. She just wanted to show the court the driveway. Is that correct?
That's correct. Yes.
I thought she said that she was going to...
Yes, I guess...
Mr. Brown had positioned his car.
Okay.
Oh.
Okay.
And my point is, Your Honor, you can see that the driveway is quite large.
Mm-hmm.
So, there's room for him to park. Generally speaking, he parks in front of the garage doors as if, he was going to pull into the garage door.
Okay.
This is the first time that I have ever seen him park like that across where he was blocking or impeding my entrance or exit from the garage.
Okay.
And, based on my history with him, I felt that was, an aggressive and intimidating move on his part.
Okay. Anything else?
I have, like I said, the other witnesses.
Okay. Any questions?
Lots, Your Honor.
You do?
Well, yeah. Briefly. Mrs. Sanchez, you voluntarily drove into your garage, correct? Nobody,
After a bit, yes.
well, nobody was forcing you to drive into your garage, is that correct?
No.
And Mr. Brown, you say, positioned himself in such a way as to prevent you from leaving the garage that you entered.
That's correct.
Okay. But you had to ask him to move his car so that you enter the garage?
Yes, after he saw me maneuvering, trying to get in, and he just
Okay,
sat there and looked at me.
ma'am, I asked you a question. How did you get into the garage if Mr. Brown did not move his car?
He eventually did.
After you asked him to move his car?
I said that earlier, Mr. Bouquet.
Okay,
When
you
he
asked-
Excuse me.
Yes.
Let the question finish. And he is interrupting because you're not being responsive to the question.
Okay.
How many times did you ask Mr. Brown to move his car before he moved it?
3 times.
So you arrived at your home.
Mm-hmm.
Mr. Brown, you claim, was blocking both garage doors with his car.
No, he was blocking one garage door. The other one is not able to, you can't move in there, there's stuff in there. So only one is in use.
Okay. And you asked Mr. Brown to move his car, which he did, correct?
Yes, eventually.
And then you moved your car into the garage.
Yes.
And then it's your testimony that Mr. Brown reassumed or assumed a position that you claim blocked you into the house.
He got even closer after I got in. He blocked me crossways.
Okay, so your testimony is that after you pulled into the garage, Mr. Brown was actually closer to the garage doors than when you arrived and you had to ask him.
Yes.
And you say that you summoned the police?
Yes, I did.
And this was all on June 30th, 2006.
Friday, yes.
Mrs. Sanchez, you're a member of the Maryland Bar?
No, I'm not.
You're not a member of the Maryland Bar?
No, I'm not.
you're a member of the Pennsylvania bar?
Yes, ma'am.
Are you a member of any other bars? And you are an attorney, and you've been in practice as an attorney for how many years, ma'am?
Administrative attorney, I have been for 15 years.
Now, this is the fourth or fifth domestic violence action that you filed in this court.
It certainly is.
Well, is it the fourth or the fifth?
I believe it will be the fourth.
The fourth. Well, you filed one that was dismissed, didn't you? Before it was ever, the judge refused to sign it, didn't it?
No, I don't know anything about that.
And the last action you filed, there was a full hearing before Judge Nichols, and he dismissed your case. Isn't that correct?
Yes.
And that you filed shortly after Mr. Brown noted his appeal in the underlying custody case. Isn't that correct?
I don't know.
And the time before that, you filed a domestic violence action against Mr. Brown because he came into the house to gather his personal belongings. Isn't that correct?
If you want to put it like that, that's not how I would have termed it.
Well, and there was no order barring Mr. Brown from going into what was then the marital residence, was there?
I know, but why didn't you just ask? Why did he have
Mrs.
to
Brown,
break in?
I asked you a direct question.
What's that?
It's a simple question, and I've asked this question before, haven't I? In fact, I've asked it at the preceding 3 domestic
Well,
violence
could you
actions.
repeat it, because I'm not sure.
Mr. Brown, there was no order barring Mr. Brown from re-entering the house
No, there was
to
no
collect his personal belongings, was there?
There was no order. It was just
Okay.
the manner in which he did
And
it.
ma'am, you also, well, you weren't present in the home at the time Mr. Brown entered, were you?
No, I wasn't.
In fact, you encountered Mr. Brown leaving the home on the street. Isn't that correct?
No, I did not.
You didn't.
No,
You
I
didn't
did
drive
not.
by Mr. Brown as he was leaving in a truck?
Not that I'm aware of.
And
What was the domestic violence in that case?
Excuse me?
What was the domestic violence?
There was none, Your Honor. That's my point.
The domestic violence was, Your Honor, we were at church. Mr. Brown broke into the house and just destroyed the bottom level of the house. He never asked for anything.
Why don't
He just
you
came
say-
in and tore the house up.
Your Honor, I mean, if necessary, if the court wants to give any credence to what Mrs. Brown said, I have a videotape of the entire episode Mr. Brown was intelligent enough to take when he went into his home. And it's been offered to her counsel in the past. I can't present it to the court to see.
Okay, next question. Next question.
And ma'am, you filed the first domestic violence action that you filed against Mr. Brown was because you claimed that he threatened to kill you and or the children. Is that
Yes,
correct?
that's correct.
Okay. And that threat was in the form of a newspaper that he left sitting on a countertop in the former marital residence.
Correct.
And ma'am, that newspaper, as we've already discussed on 3 prior occasions, or at least 3 prior occasions, was in fact a newspaper copy of an advertisement for a clothing sale at the Heck Company. Isn't that correct?
No, it wasn't, Mr. Buchanan. Might have been Mr. Brown claims on that same page, but no.
And you said to the judge that the 3 prior actions that had been brought with the Department of Human Resources, you said that they were, quote, inconclusive, quote.
Yes, one of them I know was inconclusive.
Did you receive a copy of this letter dated October 29, 2004?
Yes.
That letter is from the Department of Social Services in Prince George's County?
Yes.
Okay. And this is pertaining to the investigation that you had pending at that time against Mr. Brown. Is that correct?
Yes.
And the term used there by the Department of Social Services is ruled out, isn't it?
Yes, but I'm confused
Ma'am,
about
it
this.
says ruled out, doesn't it?
It does, but I'm confused about that because at the same time...
Ma'am, there's another letter here dated January 16, 2001 from the Montgomery County branch of the Department of Health and Human Services.
Yes.
Do you recognize that letter?
Yes.
And that one was pertaining to an investigation that you had initiated against Mr. Brown for allegedly abusing your children back in 2001, or back in 2000. Isn't that correct?
It was supposed to be on child, yes.
And the term that is used in this letter is, again, ruled out, isn't it?
Yes.
And then finally we have the most recent one. We have a letter dated May 24, 2006 from the Prince George's County Department of Social Services again.
May what?
May 24, 2006.
Yes, ruled out.
I'm sorry, ma'am. Ruled
Ruled
out.
out, yes.
Have you initiated another CPS investigation of Mr. Brown?
No.
Nothing further, Mrs.
Okay.
Your Honor, I have something. I'm allowed, right?
I hear you.
Okay. There's a Maryland case, Casson, Lowenbogen versus...
We're not here for argument. I hear your argument later.
Oh, okay. Not for argument. I can call a witness now.
On what issue, ma'am?
For the false imprisonment.
How will their testimony be any different from yours?
Probably won't be significantly different.
No, not significant. How would it be any different?
I don't know. This is
Wait.
not my testimony.
What did they observe that you did not observe?
Nothing, I don't think.
Okay, so it'd be the same.
Yeah, more or less.
Just don't want to have repetitive and redundant testimony.
Okay.
Okay. So that would be the petitioner's case, is that correct? No. That would be the petitioner's case, is that correct?
That's correct.
Okay.
Your Honor, we move to dismiss.
Basis.
She hasn't stated any basis for the entry of the order to begin with. Under Maryland law, the definition of false imprisonment standard has not been met. For that, I would refer the court to Carter v. Aramark Sports and Entertainment Services, which is found at 153 Maryland Act 210. It's a 2003 case. And the elements, which is basically discussing the elements of false imprisonment, the elements of this tort are deprivation of the liberty of another without consent, without legal justification. And Mrs. Brown, as the case would also point out, you can't put yourself voluntarily into a position where you are then claimed that you've been involuntarily or improperly or falsely imprisoned. In any event, I don't think by any standard whatsoever what Mrs. Brown has described constitutes false imprisonment.
Okay. Anything else?
In the motion, no.
Okay. I hear you. Yeah.
Okay. Your Honor, there's a case, Katzen-Lowenbogen versus Katzen-Lowenbogen, 365 Maryland 122. And this case sets forth the standard for the state of Maryland that the court is to look at the occurrence of domestic violence through the eyes of the victim. And what I'm putting forth to the court is that because my girls and I have been through so much with Mr. Brown, regardless of whether the Child Protective Services have found or sustained that there was some damage or some incident, the fact is that we have been through a lot of trauma with him. We've been hit. We've been kicked.
Excuse me. I want to sustain that. There's no testimony to that.
You wouldn't let me give the testimony for that.
That which
I
brings
took
you
it on my
here.
petition.
That which brings you here today.
Yes.
I take it that if those matters occurred and you filed a domestic violence petition, either the court concluded that they'd happened and issued an order.
Right.
And I've heard that the court has not issued in a domestic violence order. And the court has not made a finding that those acts occurred.
Okay.
Okay. So that's not what brings you here. What brings you here is the incidents between June 28 or June 30, 2006.
Right. But in light of what we have been through,
There's no evidence that any of that occurred.
you wouldn't let me give the evidence.
Excuse me. What is the evidence that's not reason why you're here? You're here because of what happened on June 30th.
That's right.
Okay.
That is right.
Okay.
But what I'm saying to you is that those prior incidents...
If I may, the only issue then before the court is whether Mrs. Brown has sustained the basis for a false imprisonment claim, even when looking through the eyes of the alleged victim of domestic violence. That's the only context in which this can possibly be presented to the court.
Thank you. Anything else, ma'am?
Yes.
Okay.
So given the Katz and Logan Boggin case, my position is that we were assaulted because we were afraid and in fear of some sort of imminent harm from Mr. Brown. In addition to that, we were falsely imprisoned in my home.
Excuse me. You have not said one thing that he said.
Your Honor, my hands are sort of locked every time.
No. Your hands are not locked. I said I gave you every opportunity to tell me everything about June 30th. I kept asking, what else on June 30th? Not one time.
I told you I was afraid that he was going to do something to us.
I heard that, but you kept saying what he said. What did he say? He didn't. You haven't said. Let me stop. What is it in the record that he said? In the record that he said, or he did, other than parking his car in the driveway, which would lead to an assault? Because you just used a legal term that you were assaulted.
Right.
Okay, so what did he say?
We were in fear of imminent harm.
What did he say?
He didn't say anything.
What did he do? What did he do other than driving his car and parking it in the driveway? What did he do other than that? And that's in the record.
Okay, that's what I'm saying to you. The way that he parked, the manner that he conducted himself, the way that he looked at us, the way that he behaved is what caused the fear. Okay, it's not just a matter of he pulled the car up and he pulled the car back. It's what I know about him, what I have been through with him, the way that he looked at us, the way that he behaved, the way he rolled his eyes at us, the way he...
Wait. Your lawyer, what's in the record? That's why I gave you every opportunity. This now is argument as to whether or not the matter should be dismissed because you have not met your burden, because you have not made a prima facie case at this juncture. That's what it would be. I'm listening.
Your Honor, I tried to say that earlier, but I felt like I was getting cut off, so I was trying to tell you.
You tried to say what earlier?
That we were afraid. I said.
Well, you said that.
Okay.
I heard that.
Okay.
I heard that. Wait. That's a conclusion.
Yes.
My question was, what did he say?
He said nothing.
Okay,
non-verbal clues.
Next was, what did he do? And you've told me. He didn't do anything. He drove his car. Now it's not in the record because you didn't testify to it, but you say he rolled his eyes and that was not. You didn't say that earlier. And I kept saying, tell me what happened or about.
I know, but the way that you said it to me, it made me feel like I had to narrow it down, say it very rapidly.
Excuse me, ma'am. I kept saying, tell me what it is that occurred that brings you here to court.
Yes.
Now we're here on argument as to whether or not the defendant's respondent's motion should be dismissed. Should be granted.
Mm-hmm.
Okay, anything else you want to argue about?
No, that's it.
We're here as a result of a petition for protection from actually the particular box, no box is actually checked. It has domestic violence, child abuse, or vulnerable adult abuse. Neither one is checked. But it does indicate that I want relief for myself, my minor child, from abuse by Ronald Brown, against Roxie Sanchez, Sidney, and Tyler Brown,